मतलब डेटेड 30/4/2025 मंत्री परिषद द्वारा निर्णय लिया गया है कि सीधी भर्ती 2023 में नियुक्त 2621 बीएड अहर्ताधारी सहायक शिक्षक जिनकी सेवाएं स्कूल विभाग द्वारा समाप्त की गई है, उनको अंतर विभागीय समिति की अनुशंसा के बिंदु क्रमांक 1 से 5 हटाए गए बीएड अहर्ताधारी इतने शिक्षकों को सहायक शिक्षक विज्ञान प्रयोगशाला के राज्य में रिक्त इतने में।
तो इसमें अभी अर्जेंसी क्या है?
इसमें जो एनेक्चर P9 में है उनने प्रोसीजर चालू कर दिया।
P9 पेज नंबर
P2 मतलब पेज 19 9/6/2025 का ऑर्डर है। दिस इज ऑल्सो अंडर चैलेंज। इसमें कर दिया है स्कूल विभाग के इसमें समायोजन करने के निर्णय संबंधित कार्य काउंसलिंग के माध्यम से दिनांक 17/6/25 से आज तक प्रति दिवस स्थल सचन सच में किया जाना। Therefore the urgency is madam. This petition was filed on 13/6 madam. 9/6 का ऑर्डर हुआ है, was filed madam. अब ये निर्णय क्या लिए हैं इसको देख लेंगे पेज 14 में मैडम, 14 नंबर पेज में समायोजित किया जाना है। समायोजित गैर
जो बीएड वाले जो हटे हैं,
जो हट गए हैं, जिनका सर्विस टर्मिनेट कर दिया। अब ये जो डायरेक्ट रिक्रूटमेंट का पोस्ट है रूल्स में 2019 में, इसमें जो है सर जो रूल दिया हुआ है रूल 6 उसके शेड्यूल 2 में जो दिया है सीरियल नंबर 35, जो पोस्ट फिलअप होना 100% बाय डायरेक्ट रिक्रूटमेंट, उस डायरेक्ट रिक्रूटमेंट के पोस्ट में ये कर रहे हैं उनको एडजस्ट ऐसे कैंडिडेट को।
तो आपके बारे में क्या डिसाइड किया?
नहीं अभी मैं आ रहा हूँ सर, हमारे बारे में कुछ नहीं किया। हम
जो
तो
आपको
हम हैं एस्पिरेंट्स
हाँ।
जो हम तैयारी कर रहे हैं
हाँ।
कि इतने पोस्ट वैकेंट है डायरेक्ट।
अच्छा, आप वो टीचर्स नहीं है जो हटे हैं?
जो हम हटे हैं वो नहीं,
आप फ्रेश कैंडिडेट्स हैं।
कैंडिडेट है जो
इतने साल अभी तो एडवर्टाइज नहीं है।
नहीं है ना, इसीलिए तो हम लोग फाइल किए हैं इसको।
अभी तो कुछ भी नहीं है।
नहीं अच्छा, अभी तो उनका कंसिडरेशन हो रहा है।
उनका हो रहा है सर एडवर्टाइजमेंट। हम सर
इनका ये अप्रीहेंशन है कि यदि ये कंप्लीट हो गया प्रोसीडिंग तो वो जो फ्रेश एडवर्टाइजमेंट जो निकला
है कभी पोस्ट वो कभी निकलेगा ही नहीं।
हाँ,
और हम हो जाएंगे,
चांसेस कम हो जाएंगे
और एज बार हो जाएंगे हम। अब इसको आगे देखिएगा सर, पैरा 3 में क्या बोलता है। कला वाणिज्य संकाय में 12वीं उत्तीर्ण सहायक शिक्षकों को निर्धारित अहर्ता 12वीं गणित विज्ञान पूर्ण करने हेतु 3 वर्ष की अनुमति दी जाए। साथ ही इन अभ्यर्थियों को प्रयोगशाला कार्य में संबंधित सच एंड सच के माध्यम से 2 माह का विशेष प्रशिक्षण दिया जाए। 2 थिंग्स हैज बीन रिलैक्स माय लॉर्ड। एक तो जो है एक तो डायरेक्ट रिक्रूटमेंट के पोस्ट में है, बोले इनको एडजस्ट करेंगे वहां। दूसरा ये कर दिया कि जो गणित जो कला आर्ट और
नहीं, जो सहायक शिक्षक प्रयोगशाला है ये डायरेक्ट रिक्रूटमेंट
है, वो मैं बताऊंगा अभी आगे। दूसरा रिलैक्सेशन क्या दिया पैरा 3 में कि जो अगर आपका 12th अगर आपका आर्ट्स या साइंस उसमें है कॉमर्स में, then you will be given 3 additional time to pass 12th examination with a science discipline, science or maths करके। Two things have been relaxed by the state government by taking policy decision madam। अब ये रूल्स देख लेंगे मैडम। एंड pursuant to this order my lord, this was passed my lord। ये 9/6 का जो ऑर्डर पास कर दिया एनेक्चर P2 में, पेज मतलब 19 मतलब 9/6/25 pursuant to order passed by the ये छत्तीसगढ़ शासन विभाग द्वारा आदेश दिनांक 30 शिक्षक विज्ञान प्रयोगशाला के पद में समायोजित करने का निर्णय लिया गया है। समायोजन का कार्यवाही ओपन काउंसलिंग के माध्यम से 17/6/25 से इतने के प्रति दिवस स्थल सच एंड सच में होगा। So this 2 order is under challenge, my lord. Now, my lord, I filed a copy of rules, my lord, at page number 21, my lord. Page 21, my lord. Now, these rules, my lord, in exercise of power conferred in the provisions of Article 309 of the Constitution of India, the governor hereby makes the following rule: recruitment for the school education services cadres, namely 2019. Has been framed, my lord. Now, my lord, page 23, my lord. Rule 6, method of recruitment. Recruitment to the service after the commencement of this rule shall be made on the following method, namely by direct recruitment through selection, competitive examination, interview and limited departmental examination. Rule 6, my lord. Now, my lord, if my lord may schedule 2, my lord, at page number 36, my lord. Under rule 6, my lord.
Page number?
Page 36.
36. Schedule 2.
Schedule 2, rule 6. इसमें 5th कॉलम देखेंगे आया है 1 2 3 4 5 जस्ट ऊपर देखेंगे बाय डायरेक्ट रिक्रूटमेंट सी रूल 1A
6-1A।
हाँ, फिफ्थ में अब इसको मतलब पेज नंबर 40 40
यस।
असिस्टेंट टीचर साइंस लेबोरेटरी 100% थ्रू डायरेक्ट रिक्रूटमेंट। Rule 8 provide my lord condition for eligibility for direct recruitments at page 23 again my lord.
Page number
23 my lord. Condition of eligibility for direct recruitment. वो जहाँ रूल 6 है उसी के नीचे आया होगा।
6-1A।
हाँ 6-1A आ गया, उसके नीचे रूल 8 है कंडीशन ऑफ एलिजिबिलिटी ऑफ डायरेक्ट रिक्रूटमेंट। इसमें आएंगे पेज 41 में my lord now again.
Page 41
serial number 2। सीरियल नंबर 2 असिस्टेंट टीचर साइंस ये वो मिनिमम ये मैक्सिमम एज 35 पास हायर सेकेंडरी एग्जामिनेशन विद बायोलॉजी ऑब्लिक मैथमेटिक्स सब्जेक्ट। तो मतलब द स्टेटरी रूल्स प्रोवाइड दैट द मेथड हैज बीन प्रिस्क्राइब्ड फॉर द सिलेक्शन ऑफ द कैंडिडेट्स मतलब इन अ डायरेक्ट 100% डायरेक्ट रिक्रूटमेंट विद क्वालिफिकेशन हैविंग पास secondary examination with biology.
So this rule has not been relaxed or not modified.
This has been not been relaxed or modified or my lord amended. Anything has been done. In a cabinet, my lord.
Yet they have considered them.
Them, my lord. Sympathetically, they have considered them. What they have argued last time, my lord. What I can understand, my lord. And to accommodate them, a policy decision was taken by the state government, my lord. By relaxing not only, my lord, that education qualification plus the post of the post which has been otherwise reserved, my lord, for to be filled up by the 100% direct recruitment, my lord. A policy decision has been taken, my lord, to adjust those candidates who are out of service, my lord. Their services is to terminated by the order passed by the division bench, upheld by the Supreme Court, my lord. And the last date, my lord, they have argued, my lord, also filed the intervention saying that after cut-off date they have been, so no vested right upon them to claim. But due to this policy decision, my lord, the decision has been taken to accommodate this very procedure and the exercise of the power is under challenge. Now, my lord, this order says, my lord, page 14, my lord. 14 छत्तीसगढ़ के राज्यपाल के नाम तथा आदेशार, my lord, this the business of the conduct of rules, my lord, says that, my lord, prior to any policy decision whatever, this order has to be issued in the name of governor. Therefore this has been issued, my lord, under article 166 of the Constitution of India. Now, my lord, the rule 22 also says, my lord, provides. Well, this I am arguing, my lord, since they have raised an objection in their intervention and, my lord, the impediment applications. Page 21, my lord, page 32, my lord. Rule 21, my lord, relaxation. Nothing in this rule shall be considered limit or abet the power of the government to deal with the case of any person to whom this rule may apply. Now, my lord, I ask myself a question. Suppose I have been terminated. Whether I can claim any, my lord, diligence or the power, exercise of the power of the governor saying that under this rule, I am granting you relaxation. There is no such power passed, order or relaxation order passed or any notification issued, my lord, with this respect, relaxing any of the provisions of this act which has been statutory rules framed under Article 309 of the Constitution of India.
Yes.
No, my lord. Another, my lord, submission, my lord, what they have, my lord, raised, my lord, that regarding my locus, my lord.
Yes.
My lord, I have pleaded in my petition, my lord, writ petition that is required to be answered by the state government, my lord. (8.9), my lord. The right point that the petitioner are having the requisite qualification and already passed the higher secondary school in the science subject and holding degree in science background. The respondent state cannot act arbitrary manner affecting the chance of the petitioner who are eligible by filling up the vacancy of direct recruitment by way of absorption, that to rehearse the statutory rules framed under Article 309. 8.10, the state is required to secure all the citizen and adequate means of livelihood to right to work, and such appointment process must be transparent, not in violation of the constitutional right under Article 16 and 21 of the Constitution of India. 11 में और last, the ineligible candidate depriving the petitioner who are eligible for appointment and whose chances were affected by filling up of direct recruitment by way of absorption. यहाँ adjustment कर रहे हैं उसमें, जो adjustment का तो word ही नहीं है पूरे उसमें है rules में. मतलब पैरा 9.6 मतलब ground. The petitioners, the executive decision depriving the petitioner of their chance were affected by filling of the vacancy of assistant teacher science laboratory by way of absorption, though no person can claim government job, but the appointment process must be in accordance with the statute in a transparent and a fair manner. The state government is required to secure all its citizens, including the petitioner, adequate means of livelihood and right to work, but the state government, by taking arbitrary decision, chance of the petitioner to appointed against the vacancies were affected. Therefore, the petitioners are aggrieved party and filing the instant writ petition. And 9.9 also, I in specific terms, needed that, the state government, being the beneficiary state, is required to act fairly and not deprive the right of their own citizen by adopting the method of appointment which is not prescribed in the statutory rules and depriving the petitioners who are waiting since long and are preparing to compete in the direct recruitment post of the assistant teacher science laboratory, and there are vacant posts available to this decision of the absorption of the petitioner who are eligible for appointment. Chance of the petitioners are affected by filling vacancies of the direct recruitment through absorption. And now, so far as
yes,
the judgment of 2018 volume 13 SCC
volume
13
page number,
start from page number 560 में, state of UP versus Anand Kumar Yadav. Now my lord,
para number,
it starts, my lord, the relevant would be, my lord, I am relying upon from para 13 onward, my lord, page
13.
5, para 13, page
13,
number
13.
13, page 577.
Yes.
Here, my lord, it starts from the proceeding before the High Court. Batch of writ petitions was filed before the High Court by the person who claimed to be eligible for appointment and whose chances were affected by filling up.
This judgment is with respect to the locus.
Locus. What they are saying that I have no locus. The aspirant has no locus. Though we will proceed, rehearse the rules.
They are saying that even at right now you are not the aspirant. You may be the aspirant.
यही exactly यही केस है जो मैं बता रहा हूँ. आप पैरा 13 देखेंगे, उसके बाद जो प्रोसीडिंग हुई वो भी मैं दिखाता हूँ. Batch of writ petitions was filed by the High Court before the High Court by the person who claimed to be the eligible for appointment and whose chances were affected by filling up vacancies of teacher by regularizing the Shiksha Mitra against the said vacancies, praying as under. Now I am also in the same footing. I am also, my lord, the same footing like that, my lord, which has already been adjudicated. The person claiming eligible, I am eligible for the appointment. My chances were affected, my lord.
Yes.
By filling up the vacancies by teacher. यहाँ कैसे fill up कर रहे हैं? जो terminated teacher है, उसको direct recruitment में post में by way of adjustment.
Terminated नहीं है.
Terminated है. Termination का order पेश किया है सर.
Termination by way of any misconduct और वो नहीं है उनका.
नहीं.
Literage है. Literage.
Literage
By
नहीं
way of
है.
order of
By way of the order of the court.
Order of the court. So their status will be the terminated.
Yes, sir.
In which post they have? In which
also
post?
comes within the purview of literage.
They
And
can
there is a
argue that.
provision.
My lord, they are appointed against the vacant post by competitive examination in the post of assistant teacher.
Earlier they have been selected. Now by the order of the court that they are not eligible for that post, they have been wrongly selected for that post because they are the higher, they are having the higher qualification more than the requirement.
जो prescribe है वो नहीं है इनके पास qualification.
नहीं,
उसके higher B.Ed था.
हाँ.
Requirement was D.Ed.
B.Ed is not required for the class 1 to 5.
हाँ.
तो उसलिए.
वो ठीक है, पर वो settle हो गया कि वो D.Ed के लिए.
बाकी अलग से separate सबका termination order has been passed by the state government. Let them deny कि termination का order pass नहीं किया करके.
तो बोल ही रहे हैं ना.
Terminate किए. Services is to terminated word भी यही है दोनों judgment में. I filed that copy of judgment.
मतलब you mean to say कि their order is termination, but by whatever means.
Suppose, मतलब A has been terminated for whatever reason. These rule provide for adjustment against the direct recruitment post. Having no qualification, relaxing that qualification. सवाल ये इशू ये है कि जब statutory rules frame है 309 में, then whether by way of executive orders or a policy decision framed by the state government, that statutory rules can be override over that, or the statutory rules will prevail. The issue is that
yes,
इज नॉट द केस. बोलते तो अपने ऑर्डर में लिखते ना 30/4 को हम रीप्लेसमेंट कर रहे हैं करके. व्हाट हैज बीन आर्गूड, इट हैज टू बी रिफ्लेक्टेड इन ऑर्डर. अगर मैं ऑर्डर को फिर से पढ़ दूं उसमें कुछ नहीं. so far as the locus, my lord, this judgment, my lord, आगे देखेंगे इसी जजमेंट में, the सुप्रीम कोर्ट जजमेंट, my lord, पैरा 18 सेक्शन पैरा 18 में, my lord, अगेन उसमें भी रिलैक्सेशन ऑफ द मिनिमम क्वालिफिकेशन में दे दी, अपॉइंटमेंट ऑफ टीचर ओनली फॉर अ लिमिटेड पीरियड, सेम इशू. Then, my lord, in para 9.18, one of the argument advanced that order 1 rule 8 of has not been followed as all the Shiksha Mitra has not been implemented as a party before the High Court. Two ground has been raised, my lord. Now this has been already been answered, my lord. Para 26, my lord.
Yes.
We are in the agreement with the above observation of the High Court whereby 1.78 lakh Shiksha Mitra has been, my lord. Unqualified teachers ought to be allowed to continue ignoring the legislative mandate and exercise jurisdiction under article of the said mandate, considering the careers of such and such over the above the legal rights cannot be the
Para
cost.
26 पढ़ा है ना?
Para 26 cannot be the cost on the fundamental right of the children such and such terms of the legislative mandate. Then, my lord, I will, my lord, straight away the concluding paras, my lord. Upholding the judgment of the Supreme Court, my lord, whereby the, my lord, the similar situated petitioners have approached the High Court in a bunch of petitions saying that our chance will be affected due to your illegal act which is against the statute. 1.75 teachers have been, my lord, terminated, my lord, and in para 31 it was held that, my lord, since we have given the full hearing to all the Shiksha Mitra through their respective counsel, it is not necessary to consider the argument of the breach of any procedure under order 1 rule 8 CPC. On the other hand, we have come to the conclusion person of the regular such and such in the even for
इसका क्या मतलब? Since we have given full hearing to all Shiksha Mitras, इसका क्या मतलब है?
But all we have
Because there is an observation that the Shiksha Mitras whose services are being affected, they have been heard.
they've been.
What does it mean?
Order 1 rule 8 देखना पड़ेगा, suit for representative to.
नहीं, the Honorable Supreme Court has observed in its order
Yeah.
that all the Shiksha Mitras have been heard. Here.
To their respective counsel, it is not necessary.
So meaning thereby they have been noticed. They have been noticed.
All affected are before lordship.
नहीं आए हैं ये अलग बात है.
अभी मेरे
all are not before the honorable court. All are not before the.
When the writ petition was filed, my lord, when the decision was taken, 30/4 को लिया, 9/6 को बना दिया कमेटी. 30/4 को जब डिसीजन लिया, have they published any list saying that these are the affected parties along with that order that are required to be considered, so that the common man or the petitioner like came to know that who will be the affected out of this. ये तो जब पूरा सिलेक्शन हो जाएगा इनका, इसका नाम आ जाएगा, 9/6 के बाद कंप्लीट करके जब प्रोसीजर ये बताएंगे तब हमको मालूम चलेगा कि दिस आर दैट. अभी तो ऑनगोइंग प्रोसीडिंग है. ये केस ऐसा नहीं है कि मैंने रिट पिटीशन फाइल किया और ये सप्रेस करते हो कि दिस आर द राइट हैज बीन एक्रूड इन देयर फेवर. राइट हैज येट टू बी एक्रूड इन देयर फेवर बाय द कमिटी कॉन्स्टिट्यूटेड.
Yes.
So far as locus and that, my lord, that being the citizen, my lord, and my lord, their beneficiary state, my lord, everyone has right, my lord, and I have a chance to participate or either, my lord, get selected. So they cannot say that you have no locus and they are affected. My lord, ongoing proceeding is there. Final list आया नहीं है that who will be the ultimate affected out of that. And my lord, one of the judgment, my lord, this AIR 2025, my lord, Supreme Court cases 1318.
Volume?
AIR. AIR 2025 Supreme Court 1318.
1318.
1318.
Para number?
पैरा 54 मिनट।
54, yes.
54,
Yes.
54 my lord.
Mm-hmm.
With respect to my lord that whether any aspirant has a right to approach the writ court,
ये भी लोकस पे ही है.
locus पे, उसका मैं लास्ट के 5-6 लाइन पढ़ दूंगा. Writ court may, upon reaching to the required satisfaction, intervene in such manner and make such direction and circumstances warrant. We therefore do not find to assert that the aspirant not having an
Indefeasible or vested right
of appointment do not also have the right to question any decision adverse to their interest affecting achievement of their goal to secure public employment, whether and to what extent any relief should be granted must depend upon the facts of each case. ऊपर पूरा ये डिस्कस किया है मतलब.
हाँ, तो इसमें तो बोल दिया है ना, and to what extent any relief should be granted must depend on the facts of the each case.
हाँ, मैं बता, मैं आपके सामने जो facts of the case लेके आ रहा हूँ. With regard to my lord violation of statute 309 में जो rules frame हुआ है, having the statutory force cannot be override by any policy decision framed by the state government without any relaxation or the order of the governor. That my lord, this judgment my lord, one of the judgment my lord, 2022 volume 12 SCC.
Page number?
Page number 1.
100.
Page
1. Yes. Para
29. Page 27.
29, हाँ.
Para 29.
Where there is a conflict between
where there is a conflict between the executive instruction
तो executive instruction cannot override the.
मैं इसको इसलिए बार-बार पढ़ रहा हूँ क्योंकि इसमें यही था, एब्जॉर्ब इनने क्या किया था कि प्रमोशन के पोस्ट में एब्जॉर्प्शन कर लिया था इन दैट, saying that in absence of any statutory rules no decision can be made. इसके लिए इसीलिए रिलाई कर रहा हूँ. पैरा 29 हो गया. Appropriate legislature, the law will prevail where the rules were scattered and a situation where there is a gap, the rules executive instruction can supplement what is stated in the rules. अगर रूल्स में बोला ही नहीं है, एनी इंस्ट्रक्शन कैन नॉट सप्लीमेंट दैट. पैरा 33 मान
Yes.
There is a fundamental faulty submission which has been urged on behalf of the appellant. Administrative instruction, it is well settled by the supplement rules which are framed under the provisions of 309 of the Constitution of manner in a manner which does not lead to any inconsistency. Executive instruction may fill up the gap of the rules, but the supplementing the exercise of the rules making power with the aid of the administrative or executive instruction is distinct from taking the aid of the administrative instruction contrary to the express provisions for the necessary intent of the rules which were framed under Article 309. The rules such and such, उसको मैं skip कर रहा हूँ. The absence of provisions for filling up of the post of the commissionate by absorption of a person belonging to cadre of the another clearly indicate that the cadre is treated as a posting until the no occasion absorption person from the outside the cadre who hold a similar or comparable post. Now one of the arguments, my lord, that since this order one of the judgment, my lord, AIR 2023 Supreme Court.
AIR
2023 Supreme Court 1591.
1590.
1591.
91.
91. Again, my lord, with respect to Article 309, my lord.
Para number?
Para, my lord, 31 and 32, my lord.
Yes. ये भी उसी पे है ना, गवर्नमेंट
उसी पे
रेजोल्यूशन
है,
कैन नॉट
उसी पे
ओवरराइड द
है।
स्टैट्यूटरी
मैं
रूल्स।
उसी के लिए दिखा रहा हूँ।
यस।
नाउ my lord, one of the judgment, my lord, ILR 2019 छत्तीसगढ़ 65।
हाँ
para 10, my lord, 10 onward.
यस।
This I am relying, my lord.
Hmm.
This I am relying. Since in, my lord, Annexure P1, page 14, my lord, in order dated 30/4/2025, it was mentioned that
पैरा नंबर
para 10 onward.
10।
नहीं, वो पैरा इसमें इसको रिलाई कर रहा हूँ, दीजिए।
नहीं, ये जो आईएलआर का बता रहे हैं
हाँ, para 10, para 10.
पैरा 10 ना।
Section 241 of the Chhattisgarh General Clause Act define the state government as under state government such and such. Is para skipping that, my lord, the judgment which has been quoted. Para 12, it is well settled that all executive actions of the government of India and the government of the state are required to be taken in the name of the president of the governor of the state, as case may be under Article 177(1) and 161. Order of the instruction made of the executive in the name of the president or the governor of the state, as the case may be, as required to be authenticated in such a manner as may be specified in the rules made the president or such lays down. Then 77(3) has been quoted, my lord. Para 13, my lord, Article 166 has been. My lord, Article 166 has been quoted.
यस।
In para 15, my lord, 14. In this, my lord, I would like to, my lord, only submit that इस ऑर्डर में जो लिखा है छत्तीसगढ़ के राज्यपाल के नाम से तथा आदेशित जो ऑर्डर है, it is the decision of ministers of council, not the decision of the governor. Now, every policy which has to be made by the or any decision, it has to be issued in the name of governor under Article 166. So this policy decision was taken by minister cabinet in a cabinet meeting, my lord, headed by the chief justice. This decision was taken and issued in the name of governor to fulfill that administrative requirement under Article 166. It cannot be said that this is the order passed by the governor relaxing the rules under section 20, rule 21, or any notification or order passed under Article 309 of the Constitution of India under, my lord, this rules 2019.
Yes.
And therefore, my lord, interference is called for, my lord, by the honorable court, because the exercise this policy decision against the statute, my lord, the number of judgment, my lord, was held that, my lord, it cannot be sustainable.
Yes. Yes, Mr.
And
Kali.
so far as locus I have submitted, my lord, judgment, it is not the case that the aspirant has no right. Even the one of the judgment traveled to the Supreme Court, my lord, whereby the entire selection has been on the same footing, my lord. I am also on the same footing, my lord. Instead of taking, my lord, recourse, pardon the prayer, what I read in the writ petition, my lord, is also relevant, my lord. (10.3), my lord. To fill up the vacancies of the direct recruitment post assistant teacher strictly in accordance with the rules of 2019 in a fair and transparent. इनको करना है transparent manner में करें, and so far as that, my lord, the quashing of that order either both order, that is, my lord, the order, the policy which has been taken, my lord, 30/4/2025, and, my lord, the constitution of the committee, my lord, 9/6/2025. In absence of any rule or a power, my lord, the entire selection process is, my lord, by demand.
Yes, Mr. Kali.
Lordship. Lordship is very well aware about the background of the case.
नहीं, हमको कुछ नहीं मालूम है।
हाँ, Lordship.
तो दूसरे केस में
वो
उसका मतलब
नहीं वो तो
हाँ, बताइए।
by virtue of order of honorable court, Lordship, the 226